In Massachusetts, if you are considered a danger by a judge, you can be held for up to 180 days without the chance of being bailed out. That's a pretty harsh consequence for a system that says innocent until proven guilty. Basically, what happens in a dangerousness hearing setting is there is a two-step process. The first one happens at the time of arraignment. And once again, the arraignment is the first step in court in the criminal justice system, where the Commonwealth tells you what you're being charged with, and issues such as bail and a dangerousness situation are addressed. If you are charged with one of a number of enumerated crimes, and the judge finds that there is probable cause to believe that you committed those crimes, you can be held up to 6 months without the chance of getting out. Essentially, those crimes involve crimes of violence. Typically, we see them in assault and battery against a household or a family member. They can be used in OUI charges, where it is a third or subsequent offense, or any number of other violent charges, or gun charges, or something that could end you up with a mandatory minimum sentence of up to 3 years. There are a number of charges that could apply. So at arraignment, if this is going to be an issue, the Commonwealth will file a motion in court asking that you be held in custody pending a full dangerousness hearing. The motion basically has two parts to it. First, it has to assert, and the Commonwealth has to prove to the judge, that you are being charged with one of the certain specified crimes that we just discussed. The second prong is that the judge has to find that there is probable cause to believe you committed that crime or those crimes. Now, a probable cause standard is a very low standard. It is not a beyond a reasonable doubt standard that happens at trial, or even a clear and convincing evidence, which will apply to the second stage of this process. There just has to be probable cause. It's easy for a judge to find this, and we find that it's easy for a defendant to end up in jail behind a dangerousness hearing situation. If the judge does find that one of the charges being leveled against you is one of the charges that's involved in the dangerousness statute, and that there's probable cause to believe that you committed those crimes, you will be held for 3 to 7 days, longer if good cause exists, and you will be brought back for a second stage hearing. At this point, there is a full hearing on whether or not you are a danger. The Commonwealth, that is the government, has to prove to a clear and convincing standard. And the clear and convincing standard is somewhere between probable cause and beyond a reasonable doubt. In any case, the Commonwealth has to prove that you are a danger to one particular person or the community at large, and that there are no less restrictive means to assure the safety of the community. There will be evidence presented, documentary evidence such as the police report, your Board of Probation, your criminal record if you have one, and any other supporting documents, photographs, and the like. Also, live testimony can be taken from witnesses, typically police officers, alleged victims, and eyewitnesses to the alleged incident. But sometimes the Commonwealth just goes off the papers, as they say, where they just submit all the documentation to the judge for his or her determination. At that hearing, your attorney has the ability to cross-examine any live witnesses that are presented, object to any documentary evidence that he or she feels is improper, and your attorney has the opportunity to present your side of the situation, to present your defense, if you will. After both sides make their arguments, the judge will consider whether the burden has been met. Keep in mind that there are 2 steps the judge must take in order to find you and hold you as a danger. The first is that he or she has to find that you are a danger to a person or to the community at large. And secondly, that there are no less restrictive means other than incarceration to protect those people. The second step is oftentimes where your attorney can win your freedom, at least temporarily, while the case is progressing, rather than have you locked up in jail. Such common less restrictive means include things such as to be released to a person in their custody, that they will guarantee that you will be of good behavior, not cause any problems, and return you to court on your scheduled court dates. It could be an ankle bracelet, the GPS units. Typically they are stay-away orders to stay away from victims and certain addresses, sometimes to get a job, to get education, to get treatment or continue treatment, be it mental health or substance abuse treatment. In any case, the judge has several options in order to keep you out of jail. If you are found to be a danger, and the judge finds that there are no less restrictive means to protect the community, you can be held for up to 6 months without the chance of being bailed out. Since you are in custody, you have the right to be brought into court within 30 days, every 30 days, in order to move your case forward and try to reach a resolution or a trial if that's necessary. As you can imagine, while someone's sitting in jail for 6 months without the opportunity of even having a trial, puts a lot of pressure on that person to try to dispose of their case in a plea or to push it forward to trial. A dangerousness hearing and a dangerousness motion are very serious matters with very serious consequences for you. Your very liberty is at stake. If you are faced with such an issue, please feel free to contact our office at affordlaw.org, and we would be happy to discuss your options and a strategy going forward. As always, remember that our fees are lowered using a sliding scale to make ourselves more affordable to more people. If you have any questions, please feel free to contact us.